Your guys' chat is so important to me, and I don't know how long I've been missing out on your guys' chat, but I want to make sure I'm addressing you guys just as much as everyone else. So you guys are more than welcome to come back. Don't hate me too much. There we go. All right. They're gonna hate me. I know it. I don't blame them. All right. I don't even... If I see... Yeah, you guys are still fighting. All right, that's cool. We have door. Yeah, Sarah, we get a face today. Yeah, we can't do music, so I figured my ugly mug would suffice. And it's been good, so we've been a little more engaging with y'all and trying to keep things going. So hopefully a little tie action will make you guys happy. But I've lost my entire viewer count. That's good. That's good. I don't. Is a hot dog a taco? Ooh, taco versus sandwich conversation. Also, why isn't this a mistrial now? I think that we're on the path for it to become a mistrial, honestly. I think if there's a couple more shenanigans that become aired out, it's just like prosecution's not really ready for this case and we got a mistrial. And I don't know if it's going to be enough to get it with prejudice or not. All right, what verdict do I think we will come from? So we went through 2 of the shootings, and both of those are kind of the ones that a lot of people were hanging their hats on. Well, not really. Rosenbaum was the one that a lot of people were hanging their hats on, and I don't think that there's enough evidence there to say that Rittenhouse was not acting in self-defense on that one. So with him being in self-defense of a Rosenbaum, I think that we're going to lean towards an acquittal. When it comes to the other ones, I mean, the problem is that you have to isolate this entire conversation down to Rosenhaus in the circumstance of he's there, chased, everything else, the circumstance, the context around that of when those shootings occurred. And I think that we're going to be looking towards an acquittal. Oh, I could definitely go for some cheese dip right now. I didn't even eat lunch earlier. Is cereal a soup? So I think that we're going to be moving down towards an acquittal. We may be seeing a mistrial. That may even come before the acquittal. And just judging by the queasiness that the judge has about a lot of this stuff, it's very interesting. They showed the normalcy of using a Google Dropbox, not Google Drive, Dropbox for all the evidence, but it was just that one video that came via different means, showing that. Talking about the metadata, talking about the difference in quality, talking about taking our door away. There we go. All of those things combined really is going to put a lot of strain on just that one piece of evidence. And if they aren't capable of coming through with a good conclusion, that evidence has to be stricken from the record. And to take all of that away is going to be incredibly difficult. So that's why I think that they'll have to push for a mistrial on that. Oh, I didn't even see your comment there, Jimmy. Yeah, no, exactly. If they could just simply remove that, but I think that there's enough evidence on that case that it's going to change the way that people look at the circumstance, and so it's kind of easy to tell somebody as soon as a quote happens, hey, don't listen to that quote, right? When there's an objection to a question, right? So an attorney is cross-examining somebody and they ask a question that's a very leading question, in order just to put it in the minds of a juror, right? Why were you here at this event? And then, you know, somebody's like, oh, you know, the other side's attorney objects, and they say, you know, judge grants it, and then they say, no, you take that from your memory. It's easy to take that away. It's not easy, but that's much more easily taken away rather than an entire video. Having that be after deliberation had began, in the whole process that we've gone through to this point, to say now just take that away, it's a little bit beyond that point. I don't get why my thing isn't. There we go. It's weird that some comments are popping up and not others. I think the judge doesn't. No judge wants a mistrial. With him responding to media and constantly explaining his reasoning for making certain decisions, I think he's embarrassed. He may just be trying to do his due diligence and trying to understand that there's not going to be an easy way through on this. He does not want further embarrassment. Absolutely right. Ooh, grilled cheese and tomato soup, and watching the Titanic. We watch too much Bull. Yeah, no, we watch an egregious amount of Bull. All right, let's see what notes they have shown up. Should the jury request to view drone video be granted? Ooh, 1 for yes, 2 for no, 3 for undecided. Let's get this. Should the jury request to view the drone video be granted? 1 for yes, 2 for no, 3 for undecided. I did not get a vote in that one. One for yes, 2 for no. There is the Pepper Door caucus already created on Facebook, Tyler, if you would like to get a part of that. I might have to go through and count this. I like that we have some differences. Too much uncertainty with that video. Meg Jones has dropped a comment in the Facebook chat for you to join the Pepper Door caucus if you would like. All right. I really wish I had a pad and paper here. The question is should the drone video be granted to be given to the jury? 1 for no, 2 for yes. No, 1 for yes, 2 for no. Sorry. Just make up numbers like the Biden administration. Well, after 18 million votes. There are other videos, there's other footage from other angles. Some of you guys have already voted once and you're voting again. I think we're getting to 10-10 split right now. I think we're fairly well split, which was kind of similar. And kind of similar to what their results were. Theirs was 47% yes, 35% no, and 17% undecided. Google says it's a pepper, not a pepper. It's a pepper. It's a pepper. I mailed my vote. Okay, I got you, Tyler. No worries. Look at this. Look at this. They're making up in the comment section. I appreciate you guys. Just know that when you guys are on Facebook, take as little offense as you can from others. And try not to. The poll was, should the drone video be allowed to be given to the jury, as it's a big point of contention right now. 1 for yes, 2 for no. Wiki is wacky. I like it. Badger is a pepper. Got it. She got my vote about 4 a.m. Google can lie to you all you want to. We can see this pepper right in front of us. That pepper with the legs. Here's another picture. Here's a clearer picture of that pepper. Why have they not focused the picture for us? Look at that. Look at that pepper. That is a nice pepper. Which video, low res or high res? So the jury was shown the high res video, which is their point of they should be able to see it again. Yeah. Look at this. This is what they gave us before, and this is the schmuck. This is the stuff that they're giving us now. Look at this. A beautiful pepper, a blurry pepper. A beautiful pepper, blurry pepper. Wisconsin state animals a pepper. Yeah, you know, it goes great in cheese, eh? There we go. Look at that. Blurry peppers lives matter. Oh yeah, some good old pepper jack. Oh yeah, there. Yeah, but we're gonna be doing the hurry up and wait all day. We're currently, to anyone who may have come in recently, to give you guys the update of what has happened today. So last night, the defense requested a mistrial with prejudice because of a couple issues, including a drone video in which since then we've learned that there was 2 video files. The metadata does not match up for the different quality of the videos. The first one, the higher quality, higher res, was created, and then 21 minutes later was a lower res. But basically there's a accusation that because the defense didn't know how to use airdrop, the plaintiffs or the prosecution was unable to provide them with it, but nonetheless they progressed forward. They provided the courts with the high res file. The defense had the low res file. It's their fault, not the prosecution's fault. No addressing of the 21 minutes between the 2 videos being created. They're working now to get a blank laptop that will only have the video files that the jury wants to see. The judge is queasy about this. He was queasy about the drone video before. Now he's even more queasy because of the questions of the mistrial being asserted. He doesn't feel too easy about this. We've seen where he raised, or he addressed some of the concerns that the media has had. He's tried to create unity, saying, look, the prosecutor and the defense attorneys and myself have worked together in different capacities before. So that shouldn't be an issue, but the media is making a lot of mountains out of molehills. He's saying that there's respect amongst them. He spoke about the Kyle Rittenhouse of being able to draw the lottery winners, or i.e. in this case the jurors. Said that that's a normal thing that he's been doing since the mid-90s because of a case there. And so it's still, and I explained the breakdown of that basically, right? The defense, we have the presumption of innocence, and so the defense is presumed innocent until proven guilty, and so it's a way that you kind of just let them pick it. When I've been in court cases myself, whether as a witness or there as the plaintiff or the prosecutor, we have seen where the defense is kind of gets the first call on who the jurors are, right? They say yes, or they pick up or knock down jurors, kind of the same way you would in Guess Who. You just top them over and they fall down and you're like, next juror. But no, so they get a pick, so the defense gets a pick, and then the prosecution or the plaintiff will then accept if the defense has accepted. And so it's very similar with that. It's a random luck of the draw, so he draws a couple names and that person goes up onto the jury. So it's a little bit of a different system, but the way that courts work is really it's kind of like a monarchist system, wherein the judge has full reign over their courtrooms. Pepper, I hardly adore her. So he addressed some of those issues, and so I was glad to see those come through. And now we're at the point where the jury had asked to see some videos, wanted to know where we're going to watch these videos, how many times can we watch them, basically understand the logistics of it all. So that's been the two different times that we've seen the judge sit down and address the prosecution and the prosecutors and the defense. Where we've gotten to today is that yes, they're going to watch some videos. They're going to, as I said, they're going to get the blank laptops with just the videos. They're going to be able to watch that in the courtroom. They're going to clear out the courtroom, so there's going to be no one there, no recording devices, and allow for deliberation to happen while they're watching those videos in the courtroom. Because otherwise, the normal thing is for, better bring that table. The normal thing is for deliberation, for the jurors to remain in the deliberation room. So they're creating the courtroom to be that deliberation room while they're able to watch those videos. Let me go through the comment section real quick. Based on the new evidence about the state of Wisconsin, mistrial because they think Pepper is an animal. They shouldn't be in charge of someone's life. Well, Pepper's a pepper, and Pepper is, this door gives life. If the jury is hung, are they hoping the judge declares a mistrial before they are hung? That is one of those things, right? So just because they're hung, the judge can then make a determination on if they're going to just allow for more deliberation or if they're going to call it a mistrial because of that. So really having it be hung just falls back to the judge anyways. So I don't think, I would hope that the jurors would not be too concerned with that. How long is a jury allowed to deliberate? That really does come down to the judge and their discernment on this. Basically, the judge is going to have some form of communication to the jurors and basically say, hey, look, are you guys getting close? You know, where are you at? And giving them a couple days is not untypical or atypical, right? You can allow for them to have some time. Yes, it will not be indefinitely. What if the jury comes hopelessly deadlocked? Is that the same outcome as a hung jury? That is the definition of a hung jury. If they just can't come to a guilty or non-guilty or acquittal, then basically it falls to the judge of, do we have to have more deliberation or do we call it a mistrial? All hail the mighty Pepper. Yes. I don't think saying you're hung in court is relevant. I agree. All right, until they decide that they're going to give us a higher res, I'm gonna I'm gonna pull prosecution, and here we go, high res door, because if you're gonna have a door, you need it to be high res. It's hinge-worthy. The puns from you all just makes my day. Ugh. You know what's sad is if we don't get a verdict today, this is going to be left up to somebody else on Muddy Waters Media to come through and to make this happen for y'all. So if you could write to your legislators, ask them to expedite the deliberation, put the jurors on 2 times, 4 times speed, so that we can have a verdict tonight. If it's like last night, they'll probably stop deliberations around 7 p.m. Eastern or Central, or 6 p.m. Central. A 9 to 6 is, you got to think, right? So for a lot of these deliberations are incredibly difficult. It's incredibly taxing, so they can't stay too late. Kelsey would be a great fill-in. You're not wrong. So each one of these jurors are going home exhausted. She could bring her twin. Ooh. 3rd degree mahogany. And coffee and toothpaste jury. Socks and sandals jury. I've been accepted in the Pepper Door Caucus. If you guys have not joined the Pepper Door Caucus, can you really say Door's life? Oh, I wish, if you guys want to pay my bills for the next, until I get a new job, I would hang out all day tomorrow and give you guys the verdict when it comes out. Door is life. Does the mistrial need to be done before the jury comes back? Not necessarily. It becomes, it comes more into question of the authenticity of the mistrial if the jury comes back and let's say the jury finds, so for this circumstance, right, the mistrial has to, if it comes out after the fact, it has to go against kind of what the verdict would be. So for this to work, right, for the mistrial to be a problem, let's say they find him guilty on all charges, right? So they find Kyle Rittenhouse guilty on all charges, and then the judge determines through this investigative process with the experts and everything else, and finally understands like what wrongdoing has gone on, and decides to throw out that evidence, believes that it was enough, substantial enough to have impacted the case to lead to a charge that without that evidence would have led to a different outcome, or potentially just led to a different outcome. Then after the verdict has been reached, the mistrial is called, and then now we would either go into a retrial from that mistrial, or if it was with prejudice, basically it would reverse the decision and Kyle Rittenhouse would be acquitted of all charges. So they're calling a mistrial after the fact is the possibility of it causing major concerns is there. If Kyle Rittenhouse is acquitted of all charges and then they call a mistrial and say, look, this evidence was damning against Kyle Rittenhouse, there really wasn't value in calling that. So how do you think those people felt when they got called for jury duty for this case? Yeah, it's one of those things, like when you hear people get jury duty, it's like they hope that it's like a nice easy case. Like I would love to get jury duty and then just have like a marijuana case, because I will educate everybody, or any kind of drug case. I will educate everyone there about jury nullification, and that person's gonna be walking free. I will sell my soul to get somebody off of the war on drugs. You think civil trials are on their way? There's a potential for that. There's an increasing number of cases that are becoming civil rather than criminal, just because it's a way that government can enforce things that they can't enforce on the criminal side. Did they ever find Kaylee? Was that the girl who went missing with the boyfriend who disappeared until their parents went looking for him and then they found them the next day? Yeah, the prosecution definitely is having a lot of missteps, and they're getting highlighted. So the mistrial with prejudice is something there, because even with these missteps, they're not able to really put forth a solid case, in my opinion. So it'll be interesting to see. It'll be interesting to see the outcome. In my opinion, they have not sold the case that he was not acting in self-defense. And because of that, I think giving them a retrial wouldn't necessarily afford them in the best way either. So what happened? I missed it. How much have you missed, Joe? I'll fill you in as much as I can. We found an amazing door. You guys gotta let me know if there's sound that comes through. I was at the metadata. So what we found is that they're basically going to use this space, the courtroom, for the jury to use as a deliberation room. They're going to clear it out. They're going to get a laptop for them to be able to watch videos there. And that's going to be it. Door's life. All hail Pepper Door. Yes. I'm not saying it's a cult. I'm just saying we might get accused of it. Is it door at the bottom of column? Absolutely. They haven't even requested the sketchy video yet. No, but it's still an important distinction, just based on the handling. Here's the other thing that's important when we talk about court cases. And this may have been why the prosecution became so offended. Another reason why the prosecution may have become so offended, because once you've undermined one piece of evidence, and certainly if they can find some malice with that piece of evidence, or prove malice with that piece of evidence, you've basically undermined a lot of the other parts of the evidence that's coming forth. And so that's incredibly important as well, is to try to... Yeah, they're losing video right now. Oh no. Oh no. Here we go. We back in this. He looks excited. It's not an actual door, by the way. No, they're not feeding the audio through. We should be getting audio in a minute. Usually they're sleeping on this stuff. And we don't know if he's actually is talking in an official capacity right now. Probably is based on where he's looking. But
yes, Your Honor. I do have a laptop in front of me, and the state was in the room while I did these things. I cleared everything off the desktop and any other information I could find off the computer. There are 3 exhibits at issue. Exhibit 5, 64, and then 5 slow, which I believe is 7. Those have been saved directly to the desktop of this computer. They need to be played through the VLC Media Player app. That is the only thing that the jury needs to know about it. I already have it brought up on the screen. VLC.
It's all Greek to me.
Yes. The application is already up on the computer. All
We know.
you need to do is go through the application, click open file, and then they can view the videos.
I wonder if a little piece of plain notepad, so they have that. They probably would know, but there might be someone like me up there who wouldn't.
It's the only, I believe that Windows Media Player is the default. However, if you try and play them through that, nothing comes up. Sure, we can reset the default.
Okay, so we're all on board with that. Mr. Rittenhouse, you know what's happening here?
Yes, Your Honor.
Any question about it at all?
No, Your Honor.
Any problem with this?
No, Your Honor.
Okay.
Judge, while Attorney Wisco is preparing the computer, during this little break, we've done some more looking, and in terms of the drone video, I don't want to re-argue it, but I just want to state what happened. When Detective Howard obtained the video, he airdropped it to my phone, which is a lossless type procedure, or at least it didn't change anything. At some point, I emailed it to myself, which did not change anything, and has the file name, the long file name. I did ask Detective Howard to email it to me as well. Then it had the IMG file name that Attorney Wisco received. So somehow in this Detective Howard transmitting it to everyone, if it was emailed, it was compressed. If he airdropped it, it was complete. And that was not known by anyone until a few days ago on Friday.
Well, it pass. This may pass. They haven't asked for it yet. They wanted us to be ready, and of course we're not. But let's take a step at a time. And I just heard their bell ring, so perhaps they have something more of interest to us.
So, Judge, we've been talking. If they do come back with 5, question number 5 or whatever it is, whatever. You have talked about in great detail and length, and it's completely appropriate, the transparency of wanting this to be a fair trial and everything else. And I'm finding that difficult in that one of the linchpins of the state's case was information. Go ahead.
I'm just going to interrupt you long enough to have the material that we've agreed to go up. So if that's ready, Ms. Wisco, we'll have the bailiff take it up. They're ready for... They're ready for the video. I don't know what that means. But let's send up what they, number 4, and then I will hear the rest of what you have to say about number 5. So is that ready to go up?
Yes, I'm having problems with setting it as the default because of the way that I sanitized the computer just now. So if we can go up with the note saying must play.
Send the note up. Have the DA look at it, make sure it's okay with them.
If you can make sure they plug the power cord in because the battery is low. It says must play all videos through VLC Media.
Okay. Question 4, it's coming up. Yeah, go ahead.
What a great disappearing act.
Keep it open now so then they don't have to log in.
Yeah.
Thank you.
Excuse me.
He's got the COVID.
The It's no longer allergies. It's a cold. But go ahead. Yeah, there's no
It was
restriction
COVID.
on their use.
So, Your Honor, we were talking during the break, and the reality of it is one of the main portions of the video, the thing that you watched, however many times you watched it, right, on a video that we had the video, not the clarity and not the quality. I think that's been conceded that we didn't. We were talking about, we would have done this case in a little bit different manner if that was the situation, where we didn't have specific, and I want to say we didn't have the evidence because I don't think that's a fair way to say it, but we didn't have the quality of evidence that the state had until the case had been closed. Had rested, and we were going to open our closings on Monday. We've talked to Mr. Rittenhouse, and I'm going to be asking the court for a mistrial based upon the fact that if we're really trying to get to the heart of it, we've watched the video, I can tell you what we think, but it doesn't matter what we think because we don't get to present that to the jury anymore. And I think if we're going to try to do this in a way that is free from anybody hiding anything, anybody not having the same evidence as everybody else has, where it is clearly a level, fair playing field, we have to ask for this, and I'm asking for it. We understand that it's going to be without prejudice. We understand that the state can redo this case if the court grants it. We understand they will do it again. But then I think we will all have the same information, the same quality of videos, and I think that is required in a case like this where he's looking at a life sentence potentially without parole if he's convicted. And to not get that until the evidence has already been closed, that doesn't strike me as fair. So for those reasons, I'm making that request.
All right. I'm not going to invite you to respond yet because the jury has not requested to see number 5, and it'll still have to be addressed because the jury saw it here in the courtroom. But
I'm sorry, Judge, but if I understand Attorney Trofsky's request, this is a motion regardless of what the jury is requesting.
I think we're making that request because it's been shown, it's been pointed out, and in fact, we didn't have access. And I'm at this point, I don't think me pointing fingers and doing that is going to be the end-all, be-all. I think what it is I can tell you, and I think the state can tell you, we got a compressed version, which was not of the quality that they had. We learned that Friday, after the evidence had been closed. We learned that when we tried to play the video for Your Honor, and the state asked that their AV person be brought over to play their video, which was a higher quality. If this is a disorderly conduct or something, I get it. Talking about a potential life sentence here. So I'm making that request.
and again, I'm going to say that it has to be addressed if there's a guilty verdict on any degree. That count. Well, even perhaps on the others too. I don't know. It'll all depend on a number of factors. Then the motion will have to be addressed, but it doesn't seem to have the urgency right now until the jury, if and when the jury asks for number 5. That doesn't change the fact that they're making the motion, or that it could affect the case as a whole. But I'm not going to invite your response now until I know whether the jury wants number 5. Does that make sense? If it doesn't make sense, tell me. He was told that they were ready for everything. So, that you have the state's response.
Response invited.
Yeah.
The defendant's first attorney, after he was charged with this case, appeared on an interview, appeared alongside the high-definition version of this footage. I understand he's gone through other attorneys since then, but the defendant himself would have been aware of it. His legal team would have been aware of it. Obviously, both sides have attempted to get it, and we were not able to do so.
What do you mean you couldn't? If you know Tucker Carlson's got it, you could have subpoenaed it, no?
We didn't know that until, I think, today.
No, we knew it.
What did you think it was?
We knew it was aired on his show. We didn't know that Fox News apparently purchased and has possession of it.
Okay. Did you inquire?
We tried to find Brandon.
We tried to find the person who took the footage and who ended up being the person who came to our office with it.
I interrupted you. Go ahead.
So this is not a video that was in possession or form. It was out there in the, I guess, on the internet and in the world in that regard. And I think we're focusing on too heavily on, I guess, a technological glitch, and less on and we should be focusing that this exhibit was played. The jury is asking to see exhibits that they have seen and that the defense saw when they were played in court. What's on my phone or my laptop or the defense's phone or laptop is of no matter. What matters is the exhibit. And that exhibit was played. It was not objected to. The authenticity was stipulated to. And the defense, I understand they didn't realize it till Friday, watched this exhibit. They watched it on a television set a few feet from them. They could have watched it on the monitors here. That is what matters. That is what the jury sees. That is what they have seen. That they want to see it again is not prejudicial. It's not prejudicial in any way that the defense had a compressed version now. Obviously, they had seen or had a full version at some point, possibly prior to Attorney Richards becoming the primary attorney. But that is not the fault of the state. And the fact that some technology compressed this file without anyone's knowledge until Friday is not the responsibility of the state. And Defense Exhibit 41 has this video in it. So to pretend that somehow they're surprised or they didn't know about this video, they've tried to find it just as we did. We found it and there was a technological glitch. Or not a glitch, but I guess it worked in a way that is designed that we were not aware of. And
He drew a circle on the fence.
Exhibit 41 not only has the drone video in it, which is the defense exhibit, it also has a circle around someone pointing the gun. As I said in my rebuttal, this did not seem to be a great issue until the defendant testified otherwise.
It's me, I'm sorry.
And now all of a sudden, the defense is calling into question technology and not wanting videos in, and it's all to protect their client. And I understand that is their job. I'm not criticizing them for this, but their client lied about this on the stand is the state's position. There seems to be evidence to support the position that he lied on the stand about raising the gun. He was confronted with the exhibit. He denied it. The jury wants to see these exhibits, and I understand there may not be a final ruling on a mistrial until we see what happens or if it's even necessary. And
Yeah, they're an expert.
they had their own expert that could have looked at this video, and I'm sure did look at this video, and there were questions at the very beginning of the trial about, perhaps even before the trial, about the resolution of the FBI plane video, a whole different video. Their expert looked at that. I'm sure their expert looked at this. Their expert must have missed it, that it had been compressed somehow. This is not a resource we had available to us. And I believe the motion for mistrial is inappropriate. I don't believe it should be granted. And coming back to number 5, they're asking to see exhibits that have already been played, and with the exception of the image, exception of 155, were not objected to. And the court has said many times when the state has tried to raise these technological issues, well, there wasn't an objection. And we're asking for the same treatment now that these were not objected to. The defense has had access to the exhibits. They've had access to the drive, that they didn't realize it and we didn't realize it till Friday, that there was some sort of difference, is perhaps unfortunate, but they're also responsible for I'll withdraw that. Anything else? So the state believes that all exhibits should go back. Again, I understand the court has concerns over the still image. I understand that might be in a little bit of a different category, but in terms of question number 5, and while I have the floor, I'll just go through what they are. The FBI aerial with all person of interest marked, that would appear to be the defense exhibit that they neglected to mark and has now been accepted. The state also has one, which is Exhibit 25, which has Mr. Rittenhouse and Mr. Rosenbaum marked, but not the Zeminskis. So I assume they mean the defense exhibit, but we could send both back or have them come down and view it, however we do that. The drone video is 73. That's the full unedited exhibit that's been in evidence now for over a week. The zoomed in still image, we all have talked about that and beaten that horse to death, so I'm going to skip that for now. Then the full event video in regular and slow motion, that seems to be the drone video, as that is the only video of incident 1 that was played in slow motion, just as the only video of incident 2 in slow motion was Dr. Black's. So their expert video was submitted. Our expert video is, I believe this is actually 6 videos that they're asking for, which is the drone video. It's spliced out. So it shows the first third of the incident, the second third, and then up until the end of the shooting. And it's in regular and slow motion. And that's exhibits 581, 582, 583. I'm sorry, S81, S82, S83, S84, S85, and S86. And we believe that the jury should have full access to them. They should have full access in this room. And that's our position. I do not believe a technical reality, shall we say, or an unknown technical incident should result in a mistrial.
How would we object?
Pardon me?
How would we object to something we didn't know existed until it was over?
I didn't find that point particularly persuasive. But anyway,
it's impossible for us to do that. And if everybody in this room that's a lawyer has been a prosecutor. Your job is fairness and being a truth seeker. It's not debatable that it's not fair what happened. We can sit here all day and say it's been played. We didn't know. How is that reasonable?
Well, I persistently warned the state that, there's a day of reckoning with respect.
My Wi-Fi is
my feeling is
like failing right now. I'm so sorry for this, guys.
And I decided, I'll let.
Not my Wi-Fi, my router. As soon as we go to the next recess, I will restart everything and get it back going. I'm so sorry.
I think I made the comparison the other day of the breathalyzer, where the officer doesn't have to be familiar with how the breathalyzer does the analysis. But that's a device that has been sanctioned by the courts, and I just don't think we're at that place with this, and particularly if they've got evidence. I didn't see that in your motion about the manual.
We've learned it since I filed the motion.
Well, if they've got the manual, I don't know. It may be. I forewarned you. You've pressed with this, and that's fine. I've let it in. And my view on it now is where we are. We might as well follow through with it. And if they've got everything correct and it's reliable, then they won't have a problem. If it isn't, it's going to be ugly. All right.
I would just note that the defense I'm assuming they were paying attention to the trial, would have known on Monday when Detective Entryman testified that that version was different.
We're going to talk about it later because I've made the decision. I'm going to be played. You've suggested that it be played here in the courtroom under whose supervision? And
This becomes the deliberation room for that portion as they watch the video.
I'm going to be in the room with them.
The same people that are in the room with them now.
Well, why come down if they're just going to be looking at? I mean, are you saying that they come down and hear it with all of us in here?
No, I'm saying everyone leaves.
Okay, well, why not just leave them up there?
Because the screen, watching it on the screen that...
I got you.
And that goes, the problem we're talking about on 5 early is the request 5.
Yeah.
We're talking about the problem.
The last word you said.
The problem we're talking about on request 5 is on the front end so far. And it goes to the same thing with that television, adding the pixels on the back end. So now they're looking at it on a computer upstairs, and I don't know why they're not looking at this on a computer. Meaning 5. I put my hand on request 5.
Well, and how many times? One time? Is that what you said?
I didn't know. I think just as they're... No, I think they should be free to look at it as much as they'd like.
That would be my bias, frankly.
We've laid out.
But we've got the law that you cited the Anderson case. I have ruled in the past, and I'll rule again. The Anderson case is not applicable to images of the event, only to like state. But I'll hear you out.
Judge, that's the. I mean, I'm relying on a Supreme Court of this state's case. I understand that you're separating them, and I'm not here to. We object to it being played over and over. What I've learned from your case with the videotape or the cassette tape and Anderson, both of those cases talk about not there being an overemphasis on specific parts of evidence.
Possibly overemphasize a video of something. Unless, I suppose, if it's not an accurate video, I suppose then you could. But then you're overemphasizing it when you see it the first time.
That has been the concern of the court in having it, when I say them, having the jury have access to it. In Anderson and in, I think it's, that was part of the concern in both cases.
And I will repeat, I think it's the fact that we have to censor what the jury uses to decide. When the founders of the country gave them the power, it has to be censored by the judge. Be insulting. So I certainly I'm not going to say there aren't cases where, but for me to say, well, there's a video that is purportedly an accurate depiction of what happened, and you can only look at it so many times. I'm not going to do that. So they know the risk and they've assumed it, and so they can watch it. They'll do with it as they see fit.
So I understand they're ruling the videos. We do not object. Is not sent with them. 155.
Well, I'm going to leave you gentlemen to confer, and as you did before, and came up with a.
Do you wish? Should we put it on a drive and send it to the jury, or are they coming down here?
Why don't you give them a drive, because then they've already got the clean computer to work with to put it on a drive.
I want to use this.
And then they'll come down here, and presumably they know how to work it, or if they haven't told us they can't. They can come down here and they can operate it from wherever they're comfortable, and we'll all clear out of here. And okay.
I will work on that.
Okay, you confer and come up with an agreement to which you object. A working agreement to which you object. Now let's do the case of the state against Emmett Zier.
A state against a man's ear. All right, guys. It looks like my internet's going to be working just fine now that we are back to not watching that. I'm going to take the stream down for a couple minutes. I'm going to go reset some of my interwebs things, and hopefully we'll get through this for the next time. There is your big, beautiful wooden pepper. The star of the show returned once again. They've almost got the camera angle back, but we know what the better one is. Oof. There we go. All right. I will be back in 5 to 10 minutes. I'm going to go reset everything. We'll get the stream back up and running for you guys. I love you guys. Appreciate you guys all so much. I'm so sorry for the delay.